High courts must accelerate decisions on writ petitions where lower court trials are pending for long years. This is very important because couple of days ago, according to the reports, Chief Justice of India, Dr.V.V.L.N. Chandrachud, wrote to the Chief Justices of High Courts seeking data on cases where verdicts have been withheld for more than 3 months in order to encourage High Court judges to give speedy judgments. Chief Justice of India seemingly addressed HCs while taking up a case in which a High Court judge reserved the judgment for 10 months after the final hearing, but then released it from his roster for new hearing. The Chief Justice of India, who presided over a 3-judge bench, stated that his intention was to identify cases where judgments have been pending for a long time and expedite decisions. Truly appreciable because the delay in delivering the judgments by reserving them for longer period will require the litigants to hire new lawyers for a rehearing of the case in case it goes for a rehearing and makes the litigants incur additional expenses. Furthermore, rehearing such released cases in which verdicts were reserved following a thorough hearing would be a complete waste of judicial resources. Not just that, keeping the judgments held for months, what a judge can remember while delivering the judgment is also an important point to keep in consideration while seeking for expedition of delivering the judgments in the cases where the judgments are kept reserved. Not just that, a more serious, dangerous practice has been adopted and observed by practitioners in the high courts is that in writ petitions on the appellate side, high courts have avoided making decisions where trials have been pending in trial courts for years together. In such circumstances, high court judges admit the writ petitions without a hearing and stay the proceedings blindly, and these writ petitions then go unanswered for years while criminal trials are made to wait for years in the lower courts. This phenomenon of blind admission without consideration at the admission stage without rationale by judges must be stopped, since it leads to the abuse of judges' discretionary powers, which is well utilized by some of the senior designated counsels. As a result, the appeal to the judiciary is to focus not only on the ones that the Chief Justice of India observes as and when he receives a case on his bench, but also on the writ petitions where cases have been waiting for a long period and blind admissions have been made at the admission stage without hearing or consideration. Expediting the pending criminal appellate side writ petitions help trials move faster, as there is every chance of criminals going scot-free for years together and intimidating the complainants under the guise of pending stays which were given blindly by the high courts without any consideration. Hope this expedites the pending writ petitions where trials are pending for long years, finds the attention of the judiciary, and they act in a proactive manner in finding remedy to this menace, which has been becoming a regular phenomenon in the high courts. This should be seen as a public interest appeal by the judiciary. Thank you very much.